Good day, and thank you for watching. If you're a tenant in California and you recently complained about conditions in your rental, requested repairs, or exercised your rights, and then suddenly your landlord takes action against you, you need to pay attention because that may be retaliation, and retaliation is something the law takes seriously. Let's start with the basics. Retaliation occurs when a landlord takes negative action against a tenant because the tenant exercised a legal right. That could include things like reporting unsafe conditions, requesting repairs, contacting a housing agency, or even participating in a tenant organization. Now, here's the key. Not every action by a landlord is retaliation, but when there is a clear connection between what the tenant did and what the landlord did next, that's where issues arise. For example, a tenant reports serious repair issues. Shortly after, the landlord raises the rent, serves a notice, or attempts to terminate the tenancy. That timing matters, and it may raise questions about the landlord's intent. Here's where many tenants make a mistake. They focus only on the action itself without documenting what happened before. But in these situations, context is critical. You need to show that you exercised a legal right and that the landlord's action came after that. Now let's talk about documentation. If you believe you are facing retaliation, you need to keep records, written communications, emails, text messages, photos of conditions, dates of requests, any interaction that shows what happened and when. Because in legal matters, what can be proven matters more than what is claimed. Now, let's discuss timing more closely. California law often looks at the timing between the tenant's protected activity and the landlord's response. If the landlord takes action shortly after the tenant exercises a right, that can create what's known as a presumption of retaliation. But that presumption can be challenged. The landlord may argue that the action was taken for legitimate reasons. That's why evidence matters. Now let's talk about what types of actions may be considered retaliatory. These can include eviction notices, rent increases, reduction in services, or other actions that negatively affect the tenant. But again, the key issue is why those actions were taken. Now let's address a common misunderstanding. Some tenants believe that once they claim retaliation, the landlord cannot take any action. That is not correct. Landlords can still take lawful actions, but they cannot do so in response to a tenant exercising a legal right. That distinction is important. Now let's talk about strategy. If you believe retaliation is happening, you need to approach the situation carefully. This is not just about reacting. It's about building a clear record of events, understanding your lease, understanding your rights, and taking steps that protect your position. Another important factor is communication. While it may be frustrating, it's important to remain clear and professional in your communications. Avoid emotional responses. Focus on facts, because those communications may later be used as part of your case. Now let's discuss the role of habitability. Many retaliation claims arise from issues related to the condition of the property. If a tenant reports unsafe or unlivable conditions, that is a protected activity, and any negative action that follows may be examined in that context. Now let's talk about court. If a dispute reaches court, the judge will look at the entire situation. What did the tenant do? When did they do it? What did the landlord do afterward? And why? The answers to those questions will shape the outcome. This is not just about what happened, it's about how it is presented and supported. Finally, let's talk about the bigger picture. Tenant law is not just about rights, it's about how those rights are exercised and how situations are handled. If you believe you are facing retaliation, it is important to take the situation seriously, but it is equally important to approach it in a way that strengthens your position. In conclusion, retaliation by a landlord in California is a serious issue, but it must be understood and handled correctly. You need to document your actions, understand the timing and be prepared to show the connection between what you did and what the landlord did in response. Because in the end, your case will be based on evidence, not assumptions. If you're dealing with a tenant issue and believe retaliation may be involved, don't guess your next step. Call us at 888 6582. I'm Vince Davis, and we are all in this together.